नोट तो मिगर ही है।
70,910 का चेक है। जी सर। सीरियल नंबर 5 और ऑर्डर।
थोड़ा टाइम और लगेगा।
प्लीज सर,
1 वीक लगेगा।
प्लीज सर, just give me Tuesday,
नेक्स्ट ट्यूसडे पर।
please next।
ठीक है, नेक्स्ट
23/6 obelisk।
तो उसका बर्थडे और वो
क्या बात होगी, बर्थडे पे नहीं आना? अभी सेलिब्रेशन चल रही है।
नहीं
ग्राउंड नहीं बनता जी, ग्राउंड नहीं बनता। बर्थडे कहाँ मनाने गया वो
सर बढ़िया तो है।
नेक्स्ट वीक की डेट है। सीरीज नंबर 1 है ना?
हाँ जी। बहुत
बर्थडे की डेट लेनी नहीं थी, बर्थडे वाली डेट लेनी नहीं थी आपको। इसको बताना चाहिए था।
मालूम
नहीं, उसको बताना
नहीं।
चाहिए।
यस्टरडे उसको बोला कि तू मुझे डेट ऑफ बर्थ है, कोई आधार डाल। उसने उसका आधार कार्ड, इलेक्शन कार्ड सब डाला। आज ही उसकी बर्थ।
परेश कुमार पन्ना, दिया टर्मल।
रिकॉर्डिंग भी मारे गुड लॉर्ड।
परेशान तो फोन आदेश से है। पिछली का बिटनेस है वो।
नहीं सर,
अच्छा, क्या बात है। अच्छा,
एमएस पंड्या, एमएस पंड्या, 43 एमपी को डाउनलोड। तीसरी पीपी भगवान, गुलाम हुसैन सिंह, 33 एमपी सोलह, गुलाम भाई आओ, समझ
नॉमिनल जी
766 रेगुलर टाइम ट्यूनिंग हो रही है।
सीरियल नंबर क्या है?
हाँ दो ऑनलाइन
कितनी क्वांटिटी कितनी है?
1,20,000
बोतल
बॉटल साहब 252 बॉटल चलानी नहीं पिए ना नहीं 26।
अगर रिप्लाई तो किया ना होगा
Everybody is coming from Ahmedabad. Today, here, नहीं, I think I'm the one. Opponent number one. हाँ बस तो हाँ उन्हें repeated बोलना ओके हाँ देखो बॉक्स बस बाजू पर आ गए
Ready with the argument. Ultimately, this is 5% transfer of the three suits to combine and conduct in a one court. Under section 24 of the CP. And opposing it and the main perspective is found. And the GSFC has to file this application to combine this.
an application. Serial number question.
30 swing board
You are Parveen, Ashwin. Ashwin word. If your RCA is pending in the court of
RCA पेंडिंग बिफोर अहमदाबाद पर 65-21
सिविल अपील कैसे पेंडिंग है वो?
पेंडिंग अपील पर 166/80
अहमदाबाद जो है
अहमदाबाद है वो 65-21 सिविल सूट अपील तो पुरोहित साहब माती पुरोहित साहब 166 अपील करा
वही तो पूछ रहा हूँ मैं।
हाँ।
अहमदाबाद आप क्यों जा रहे हो अभी? मैं तो अभी तक यहीं आरसीए को आरसीए पुरोहित साहब की कोर्ट में करनी थी।
हाँ।
अब किसी कोर्ट में हमें
अभी ट्रांसफर तो मतलब बता नहीं बाकी आरसी और वो अपील 166
देखना है।
Regular CW number 160 of 2008. Please, there it is.
पुरोहित साहब
तो फोक्सो चली गई वहाँ जजमेंट माटे थे
हाँ
This photo
एट माटे थी। पर भाई तो फोक्सो कोर्ट में गई ना मुझे। अच्छा इसका तो इशू नहीं है, इसको कहाँ ट्रांसफर करवानी है?
इसको ये नेमदौर की मैटर खेड़ा में था खेड़ा का
डिस्ट्रिक्ट कोर्ट तो यहाँ है ना नडियाद है।
हाँ।
खेड़ा में कौन सी डिस्ट्रिक्ट कोर्ट है? एडीजे कोर्ट तो नहीं है?
ये सिविल सूट है सामने
नहीं आरसी है।
आरसी नहीं
ये-
सिविल सूट है
आप
ये अपील तो इधर ही है
हाँ, नहीं आप नहीं। Your Honor will pay to direction to consolidate the trial as well, hearing the following three cases appeals. आप अपनी प्रेयर करना है। Yes, 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 yes.
Regular, one of the things to issue direction to the consulate and trial as well the hearing of the following things cases of the public. First is the regular civil appeal number 160. It is pending before the impeachment court. The second is digital civil suit number 64 of 2019 pending before the learned principal senior civil judge Kheda. And the third prayer is the regular civil suit number 65 of 2021 pending before the learned senior civil judge Nadiad. The one suit 64 of 2, which is presently stayed under the section 10 of the CPC. The contention is there. So
That has been stayed?
stayed. So ये suit तो उठा के कैसे pending और consolidated करेंगे?
स्टे ही कर दिया।
हाँ और सूट तो है नहीं दूसरा तो ऑलरेडी डिग्री हो गया उसके अगेंस्ट में अपनी पेंडिंग है
बिल्कुल
उसको भी कंसोलिडेट करके सेम कैसे चलाएंगे सर मेंटेनेबिलिटी नहीं एप्लीकेशन
आप करोगे या आपके कोई और आएंगे?
मैं आएंगे विभाग से आए G2 एनेक्सर से हाईकोर्ट का ऑर्डर से
हाईकोर्ट का ऑर्डर
एनेक्सर
नहीं
एनेक्सर पर G2
हाईकोर्ट का ऑर्डर क्या है ये लोगों ने यही सेम एप्लीकेशन हाईकोर्ट में फाइल तो हाईकोर्ट ने कहा कि मैं डिस्पोज करता हूँ क्या लिबर्टी लेके चले तो लिबर्टी टू वो प्रॉपर फॉरम ये करके वापस आए तो कोई ऐसा बोला नहीं है डिस्ट्रिक्ट कोर्ट को कि यही जजमेंट देंगे ऐसे
After arguing for some time, it does not correct the present writ petition with the liberty when appropriate before the regular civil suit number 3 and regular civil number between the parties. Permission as such by it is open to file an appropriate application seeking for the competent court using regular civil suit number this. Special civil and regular civil pending in the and when such application will be filed. The same shall be decided by the competent court in accordance with law after giving an opportunity of hearing to all the parties concerned. Is made clear, ठीक है? कोई नहीं सुन लेते हैं, काम नहीं है।
ये लगभग थोड़ा बिल एप्लीकेशन सब करते हो
क्वांटिटी कट लिखी
सर 3,24,000 में कोई
बोतल
नहीं
बताओ। बोतल की संख्या
बोतल कुछ
3 लाख की लिक्वर है या गाड़ी समेत 3 लाख
नहीं लिक्वर है और गाड़ी के 2 लाख
की गाड़ी की?
540 बोतल है
कौन सी गाड़ी में जा रहा था?
स्विफ्ट गाड़ी में जा रहे थे
और कितने केस हैं?
एफिडेविट देके आई थिंक फर्स्ट
आइडिया नहीं आपको?
नहीं सर वो फर्स्ट ऑफिस आई थिंक लेकिन एफिडेविट के बाद
बताया नहीं इसने आप बेल एप्लीकेशन में भी डिस्क्लोज करना पड़ता है,
यस सर
ये तो मैंडेटरी है।
यस सर लेकिन वो एफिडेविट का वो पुलिस
आपकी इंस्ट्रक्शन होनी चाहिए।
Yes. I think first offense.
तो डायरेक्शन है
Yes.
तो वायलेट
Offense नहीं, कोई-
एप्लीकेशन ही मेंटेनेबल नहीं है
Yes.
अगर आप डिस्क्लोज नहीं करते
नहीं नहीं offense, no offense.
तो फिर ठीक है। देख लो
Yes.
रिप्लाई आने दो
Yes. Had you received?
और भी आ जाएगा रिप्लाई या आएगा
PTP करो।
लेके आएगा नहीं
Cover.
19वीं प्रोसेसिंग की है प्रोसेसिंग काफी लगी है मैं क्या लगता है कि बता रहे 19 में आप तो
20 number.
105 20 में रिप्लाई आने रिप्लाई न तो पैसा रुपया गेला 252 बोतल थी
है 20 number से 668
फिर तो 68 हमें कितनी बोतल थे
अब वो विड्रॉ में करेंगे सर।
पहले विड्रॉ कर
हाँ 542 होने चाहिए। एक महीने से रिलीज कर सकते सर।
चार्जशीट
2 लाख 84 हजार मंगवाओ की तो समय वो
विड्रॉ किस ग्राउंड पे करी
सिंपल है सर। इन्वेस्टिगेशन बात होता है नंबर
इन्वेस्टिगेशन तो फिर अभी बाकी है
जी जी विड्रॉ कीजिए आप 7 गुना बदल मेरे को मालूम नहीं था तो इसीलिए मैंने विड्रॉ की थी। मैंने सब रखी हुई सर नाम
वो
कोर्ट
फिर
ने
चेंज ऑफ सर्कमस्टांस का अकाउंट होगा
जी जी
चेंज ऑफ
नहीं
सर्कमस्टांस के भी
एफिडेविट जब हुआ मेरे को मालूम नहीं था तो इसीलिए मैंने विड्रॉ की थी।
विड्रॉ का ग्राउंड तो इन्वेस्टिगेशन था ना
नहीं नहीं और या एफिडेविट हुआ टोटल 7 गुना बताया तो मेरे को 3 ही मालूम था इसी हिसाब से मैंने विड्रॉ कर इसमें सब मैंने रखा हुआ है सब
बाकी में क्या पोजीशन है
कि सब सब कोर्ट में छोड़ा हुआ है सर मैंने जजमेंट की कॉपी लगाई हुई है और 2 ऑफेंस है सर वो क्या है कि लोक अदालत के सर मैं जजमेंट को रियलाइज करता हूँ जहांगीर वर्ष गुजरात और सर एक है तो आशीष अग्रवाल वर्सेस स्टेट ऑफ गुजरात सर।
फिर कॉपी थी
जी सर सर इसमें आई
इनकी प्रोसीड है ना विड्रॉल प्रोसीडिंग मतलब मेरी जो नहीं जाती विड्रॉल प्रोसीड है आपके पास कॉपी छे
मैंने रखी हुई है सर नेक्स्ट डॉक्यूमेंट ऑफ दिस मैंने लगा
क्वेश्चन नंबर पे विड्रॉ विड्रॉ प्रोसीड क्या नंबर पर छे
3 नंबर पर कुछ
वो तो ऑर्डर है ना
हाँ आपके वो जो तो मैंने वो सिंपल ही सर मैं दिखाता हूँ उसमें
वही 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 पढ़ना
जी, जी।
सिंपल पढ़ना हो
नहीं, नहीं।
सौखा औखा होता है
नहीं, सर, केवल
वही
उसमें-
वही वही पढ़ना
हाँ आप एक मैंने सिग्नेचर किया था
सारी बात होती है पर हमने आपके ऑटोग्राफ देखने थे
जी जी
क्या लिखा है आपने
अनिवार्य संजोग
सिंपल में मतलब
सिंपल
आपने
अनिवार्य संजोग
कौन से मोती प्रो है वो पढ़ने थे
जी 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 केवल यही लिखा था अनिवार्य संजोग सर तृतीय संबल है ये 1 महीने से सर जुडिशियल कस्टडी में
तो कोई
उसकी मदर विधवा है सर नॉट छोटे छोटे बच्चे हैं खेती की सेवन चल रही है सर
बट आपको ना ग्राउंड देखना पुरानी एप्लीकेशन में ना
जी जी
चार्जशीट का ना लिखा होगा अभी आपने
नहीं नहीं 400 नहीं
एक बार देखना पड़ेगा
जी तो विश्वास है
आपका मैडम
2,11,000 का मुद्दा माना था तो बाइक गाड़ी लेकर 4,11,000
तो वो खराब है ना
नहीं नहीं सर वो
TVS बैट
कोर्ट ने छोड़ा हुआ है कोर्ट ने छोड़ा हुआ है
कोई
मैंने 2 जजमेंट
फिर इसके बावजूद भी कर दिया ना काम
नहीं नहीं नहीं
रिपीटेड
वो सब वो पूरा विषय है सर
एक्चुअल
वो-
ऑफेंडर
नहीं नहीं
एक्चुअल नहीं मानते
वो मैंने आपको
एक्चुअल नहीं मानते आप इसको
नहीं 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 सर मैंने
डेबिट
जो
कितने बनती है 50 में
नहीं नहीं सर इसमें जो मैंने जजमेंट लगाया हुआ था जहांगीर मस्जिद उसमें क्लियर कट हुआ है सर
हाँ,
ये डिफरेंट प्रकार के ऑफेंस है 32 सर मेरे जजमेंट लगे तो भी वो जामीन लेने के लिए हकदार है गुजरात हाईकोर्ट पर प्री ट्रायल कन्विक्शन के होने की संभावना है।
जजमेंट लगाया आपने?
हाँ लगाया, वो मैंने दिया। जहांगीर वर्सेस स्टेट ऑफ गुजरात सर।
ये जजमेंट इसने आज दिए हैं? आमा
आज अभी दिए, मैंने अंडरलाइन भी किया हुआ है सर।
वहाँ पे गया अंदर।
सर आशीष अग्रवाल पैरा नंबर 4 में है सर। डिफरेंट प्रकार के सर आईपीसी हर किस्म का। इसमें तो सर जो आईओ ने बताया है, उसमें मैंने पूरा कोर्ट ने निर्दोष छोड़ा है सर।
देख रिप्लाई करना
जी सर।
आपको मैडम।
सीरियल नंबर 6 है सर क्रिमिनल में 657/2020।
आज एक है ना मटेरियल।
अपेलेंट हाजिर है सर। फरियादी आते हैं तो बात कर लेते
ये
हैं।
कल था वही है?
हाँ वही
हाँ, ठीक है।
समाधान की बात कर लेते हैं।
लगा देना डेट। आज तो कुछ नहीं है।
नहीं
सीरियल नंबर 4 सर क्रिमिनल अपील
सीरियल नंबर
4 4
4।
525 अभी
ठीक
आरएनपी आने के लिए।
है, कॉन्टेस्ट कर 70,000 का मैटर वैसे आप
उसमें सब एक तरफी जजमेंट हुआ नहीं, ऐसा लाइट भी कंपनी वालों ने खींची।
बाइक भी खींच ली।
रावत
बाइक का लोन था।
वो आ रही है।
ये कोई कंपाउंडिंग का चांस नहीं है, आपने पैसा तो लिया होगा। कितना बनता है आपका पेंडिंग कितना था?
मैं उनको 45 to 50 की ऑफर के लेकिन वो लेना
बुलाओ बुलाओ पीछा। केवल आपको सीरियल नंबर 8। एनबीडब्ल्यू पर है। हाँ सर। आप ओपोनेंट हो या एप्लीकेंट हो जी? ओपोनेंट। मगर होगी कारण आ रहता है आरोपी का आइडिया ना, फिर पार्टी को पता है कहाँ रहता है। सब यही जगह पर रहता है, यहीं पर रहती है। बोल मत केस बात। ठीक है ठीक है। आगे थे ना जुबानी में।
जी जी सर।
वो आप प्रीवियस डेट पे आएंगे।
जी
ठीक है ठीक है। आएंगे अभी पीपी साहब आएंगे।
जी
वो जो चीफ चीफ
जी,
फादर है।
बाकी
हाँ अभी ले लेते हैं।
सीरियल नंबर 9 है। अभी मैंने कहा 54/2036। सर आरएनपी आ गई है तो सेकंड सीटिंग में सर हम चला
पता करके
केवल 9।
2026 की है।
जी सर।
और एक डेढ़ महीने के
जी सर। जी सर।
हार्दिक खत्म हो गई।
बेल वेल जो हो तो मेंशन कर लेना कितना बेल आया तो। बेल कौन से दो सौ बावन बोतल है पीपी जो केस वेस है कोई इसके खिलाफ 200 666 है ना 666 हो जाती है ट्वेंटी केस आ रहे हैं 20 बहुत है हंड्रेड से ज्यादा
इसी दारू कहते हैं सब इसी दारू पाँच पाँच लीटर 100 रुपये 50 रुपये के दारू 252 है क्वार्टर है और 120 रियल के
कैसे करें
1,20,000 का सब जो केसेस बताए सब केसेस सब वो हॉस्पिटल हो गए हैं और फैसल हुए हैं
वो ठीक है
सर डबल डबल तो करना डबल पर्सन વૈસે 3 વર્ષ વિધવા ભરી હતા અને સાહેબ આજે મુદ્દામાં જે મળ્યો છે સાહેબ કે સાહેબ અમારે એનો કેનાલ પરથી ખેતરમાંથી મળે સાહેબ મારા પોઝિશનમાંથી કોઈ મુદ્દામાલ મળ્યો નથી
रिपीट ऑफेंडर है ना मुझे बता रहा हूँ
જે કેસીસ का बताया છે એ બધા સાહેબ નિર્દોષ છે ફેસલ થયેલા છે અમુક લોકો દરમાં ફેસલ થયેલી છે નિર્દોષ છે કોઈ કેસ સાહેબ અમારે પર પેન્ડિંગ હતો હાલ પણ ચાલતો નથી આ સાહેબ સપના આધારે સાહેબ અમારે
प्रेजेंटली कोई केस नहीं चल रहा
अभी पेंडिंग कोई केस नहीं
डेट ऑफ अरेस्ट क्या है तो
11 से 10 हो 11
पीपी साहब एक तो ना एफिडेविट में डेट ऑफ अरेस्ट जरूर लिखा है तो कहीं भी नहीं मिली मेरे को आज तक ये बहुत मुश्किल से ढूंढनी पड़ती है डेट ऑफ अरेस्ट एप्लीकेंट पे रिलाई ऑन करना पड़ता है
चलो है डील को कॉलम नहीं
हाँ कॉलम नहीं है कहीं भी लिख दें चाहे ऊपर लिख दें डेट ऑफ अरेस्ट ऊपर बनवा दो एक कहीं साइड में लिख दो। हाँ नीचे आ जाए अटक बोल देना ठीक है यही रखो यही रखो यहाँ वाले में इन वाले में रिप्लाई आ गया हाँ रिप्लाई पीपी साहब आप हो ना ये हाँ यहाँ रखो ऑर्डर बढ़ेगी
आई गई है 668 हाँ अब विड्रॉ करेंगे
આગળ વિઠ્ઠલ કરે સિમ્પલી વિઠ્ઠલ જે ગુના બતાડે છે બધા જજમેન્ટ કોપી નંબર પર
5
बॉटल कितने बताए थे
પર એક મિનિટ
522
500
क्या है तो पेपर आप
पुलिस पेपर में कर
खाली अगली एफिडेविट आपने
ठीक है नेक्स्ट और बेल वाला को
सबसे 64 અને 65 માં મુદત અરજી છે
ये ब्रांच पर ना
सीरियल मत दसा
पता बड़ा है अभी आया ना पता बड़ा फाइल लेके आया था नंबर 10
10 मैं अपेलेंट कर
आज साहेब 20,000 નું ડિમાન્ડ ડ્રાફ્ટ આપ્યો છે અમે.
તો 62,000 નથી.
હા 62,000 નું છે. 15% ભરેલા છે, 10,000.
ठीक है. तो लोक अदालत થી પહેલા
લોક અદાલત પહેલા પૂરી થઈ જશે. સિરિયલ નંબર 10.
लोक अदालत से 5 दिन चलेगी देख लेना.
ठीक है.
देख लो कोई मेंशन करवाना तो फिर ये शुरू कर देंगे.
છે કશું સુરેશ? તો મેન્શન કરો રાખથી ચાલુ થાય છે.
साक्षी समझ लो.
સિરિયલ નંબર 22 છે.
22 શું છે?
રિવિઝન અપીલ છે સર.
રિવિઝન અગેન્સ્ટ
મુદ્દામાં છે.
કયો નંબર?
सिरियल नंबर 22 है.
क्वांटिटी मोर देन 20 लीटर.
हाँ सर वो मेरे पास कुछ भी नहीं मिला है.
એમ નહીં,
आज वो कશું જ નહીં.
એફઆઈઆર છે તમારે? લાવો કાગળ નહીં એવું કહો છો કે
એટલે
गाड़ी आपकी थी ना?
हाँ.
गाड़ी आपकी में थी, मुद्दा माल था.
नहीं नहीं मिला. इसमें से नहीं मिला, वो कंटेनर था. कंटेनर
ये एक्सपोर्ट कर रही थी? नहीं, स्कॉटिंग व्हीकल था.
કઈ ગાડી તમારી?
2 व्हीलर थी.
सुगर रिलेशन टेंडर में चाल गई थी.
આ ગાડીનો રોલ શું હતો એવું સાહેબ?
અમે જતા હતા રસ્તામાં સ્ટાફના આધારે
આના પ્રમાણે કોણ? તમારા પ્રમાણે નહીં કહેતો, ફરિયાદ પ્રમાણે કહો.
મેં આરોપી નંબર પેલો ઉર્વિસ છે, ઉર્વિસ પર આપેલો મેં ફેરવવા માટે 3 મહિના પહેલા આપેલું છે. એમની પાસેથી કબજે લીધેલું છે.
बता नहीं भाई.
એને આરોપી તરીકે લીધેલા છે પણ ફ્લાઇટ એમાં નામથી લીધું છે.
કઈ વ્હીકલ તમે કયું છોડાવાયા છે? તમે આ બધું અંદર મળ્યું જ ને રિવિઝનમાં મારું જોવું નાખશો બસ.
23 TB 18-22 23 TB 18-22 TB.
આરોપી છે?
ના નથી.
वो ऑब्जेक्शन लगाया आपने इसका?
यस सर ये नो.
आरोपी की बेल होगी?
हो
जहाँ पे सर रेड हुई थी वहां पे पुलिस जब आई तो 10-11 लोग थे, सब भागने लगे। एक एक्यूज उसी टाइम पे प्लेस ऑफ ऑफेंस पर से पकड़ा गया और बाकी के भाग गए। तो कंटेनर के अंदर जो पूरा मुद्दा माल है 22 लाख अमाउंट है, वो कंटेनर के अंदर था। लेकिन जो स्थल पर से जो भाग गए, अदर एक्यूज भाग गए, वहां पे एक इनोवा गाड़ी थी, एक महिंद्रा बोलेरो थी और ये एक बाइक पड़ा हुआ था। ये तीनों जो है व्हीकल वो प्लेस ऑफ ऑफेंस पे से पुलिस ने कब्जे किया हुआ है।
लिक्विड नहीं मिल रहा है।
उसके अंदर नहीं, कुछ नहीं, तीनों व्हीकल के अंदर ही।
आप और ले लो।
40 कौन FIR आप ही का?
नो ऑब्जेक्शन करवा देना इसमें, सामने वाले के नो ऑब्जेक्शन नहीं हुआ वो लेके आओ।
यस सर।
इधर सबमिट होगा,
लाओ।
खुद से सबमिट होगा, क्या लगा दे, एप्लीकेशन लगा दे, ये लगा।
FIR एक्टिव है। तो नहीं
चालू करवा के नहीं
अच्छा, आप तो कुछ प्रोफिट
करवा।
आप कर एंटीसिपेटरी 648
में चाहिए आपको मेन आरोपी को तो बेल आउट कर दिया आप लोगों ने। हाँ तो ऊपर जो है जिससे रिकवरी हुई थी, तो इसका क्या इश्यू है?
उसका सन है।
जो मेन था ना उनको पुलिस ने पुलिस बेल पर कर दिया। रिप्लाई आ गया ना इसमें थाने के बाद।
फादर एंड सन दोनों
Father and
एक्यूज है। फादर ने अपनी इन्वेस्टिगेशन में ये बताया कि ये जो लड़का है मेरा सन, वही सभी माल लाता था और वही करता था। तो ये माल कहाँ से लाया वगैरह इन्वेस्टिगेशन में जरूरत है उसकी, ये पूछपरछ के लिए।
हम तो रेडी है साथ धक्का देने का, ये हुआ क्या है सर? वहाँ पे जो आदमी दूसरे नंबर में अफेयर में, वहाँ पे था ही नहीं पहला। तो ये दिखो, तो पापा ने ऐसा बोला कि ये मेरा बेटा है, लाता है ऐसा कुछ। तो पहली बात ये, दूसरी बात ये सर कि ये आदमी कुछ धंधा वगैरह करता नहीं, फर्स्ट टाइम। तो पहले दारू पीता हो या कोई आगे अपराध किए हो या गुनाह किया हो, ऐसा कुछ सब देखो नहीं उसका।
तो और धंधा नहीं करता तो ऐसा तो है नहीं प्रोहिबिशन का धंधा करे।
ऐसा नहीं।
दूसरा धंधा नहीं करता तो प्रोहिबिशन की
इन्वेस्टिगेशन ज्वाइन
नहीं, नहीं,
करेगा, इन्वेस्टिगेशन ज्वाइन करेगा, परसों मेरे को रिपोर्ट दे देना।
ठीक है।
टिल देन नो रेस्ट। उसके बाद देखते हैं क्या पोजीशन, कल इन्वेस्टिगेशन ज्वाइन करने में किसको कहेंगे। 3 दिन अरेस्ट नहीं होगा, तो इसके बाद देखते हैं क्या स्टेटस है।
11 बजे कल।
कल 11 बजे पुलिस स्टेशन, उसके बाद रिपोर्ट देना कि क्या कहाँ से लाता था, कितने केस है, क्या उसका करेक्टर कैसा है। परसों की लगा दो, डेट बता दो इनको, आइयो को बता दो।
જોડે ભાઈ પેપર પાછા એમાં 18 हाँ कल की रख
कल की रखो।
भूपेंद्र પેલું આગલી જુબાની લઈ લીધી ને
आप एक बार पूछ लो, अगर आपकी बात से सहमत है वो, आपकी एंडोर्समेंट से, फिर तो वो वापस ले लेंगे, प्रेस नहीं करेंगे, मुझे ऐसा लगता है, क्योंकि प्रैक्टिस यही है ना। प्रैक्टिस, अगर आप कौन है, लॉयर कौन है आए हुए हैं, कॉन्टेक्ट है आपका, फोन नंबर कर लो, थोड़ा सा तो एफर्ट करना पड़ेगा, कर लेता हूँ। हाँ 4 बजे आ जाए, देख लेते हैं ना दोनों में, पहला नंबर का
बात करिए।
ડીલે અમારે સાહેબ એપોઇન્ટમેન્ટ સેટરसाठी अच्छी નથી આલી ખાલી ડીલેરી
गुजरी कौन गया?
प्रतिवाद वादी नंबर 4 समावार नंबर 4
नाम क्या है उनका जी?
मंजुलाबेन चंदुभाई
ये वाले मंजुला बेन एक्सपायर हो गए ना?
हाँ
नहीं, जो भानु भाई हैं इनके लॉयर नहीं आ रहे?
जी साहब आते हैं એટલે સાહેબ મેં अपील डिसमिस फॉर डिफॉल्ट
अभी भी नहीं आ रहे कहते हैं।
हाँ तब डिक्लेयर करेल हुई નથી કે ભાઈ મંજુલા ગુજરી ગયા ત્યાં પછી આપણે ડીલનું सब કોઈ ગ્રાઉન્ડ જ નથી લે અને અપોઇન્ટમેન્ટ સેક્રેટરીની સાહેબ હજી તો આપી તો પડે બધા 22 નવમી હજી ખાલી ફક્ત ડીલે
खेड़ा में
बताइए। कितने दिन का डिले था? इसमें रिवीजन डलती है कि अपील डलती है? इसमें रिवीजन डलती है? नहीं, उसमें रिवीजन डाली है या अपील है ना? एक साल
1 मंथ और 17
उनके लॉयर कौन है?
कोई नहीं
पहले भी नहीं आए?
ये पहली बार हमारे पास पहले देखी
पहला ट्रायल में सब 2011 से 30 कोई भी और ओरिजिनल वो ट्रायल करना कोई नहीं
और एब्सेंट लगा के चांस दे दो नेक्स्ट वीक पे। आज उनकी एब्सेंट लगा था। आप क्या? बिल्कुल बिल्कुल। और इसका कोई पेमेंट नहीं किया आप लोग? बिल्कुल। 4.5 लाख।
serial number 30
134
yes तो ये ट्रांसफर एप्लीकेशन ट्रांसफर एंड कंसोलिडेशन if it is convenient for Zaire, I'll be the
Yes, yes.
If the lordships has not a list of documents which are produced with the application, I will just point out 2-3 documents in background, and then I'll take the lordships to the attention. Serial number 26 in that list is a High Court order.
Serial number
26 in that list. But just after my application, there is a list of documents. Because this checkered history is from last 20 years. The immediate was the causal field.
लिस्ट में करना है इनकी लिस्ट में करना है।
Perhaps it is that right? वो सर्टिफिकेट कॉपी नहीं સ્ટાર્ટ આજે આપી તો કે પેલા
ના પહેલા થી
ના ના તો જે અરજીની જોડે છે ને દાવા પેલી અરજીની જોડે જ
એક બંધ છે
તો અરજી પડશે ને એટલે ત્યારે કાઢવું એક લિસ્ટ ઓફ ડોક્યુમેન્ટ.
હાઈકોર્ટના સિક્કાવાળી સર્ટિફાઈડ કોપી જ છે. પછી એના પછી હા હવે ફેરવો.
इसमें सेकंड पेज पे बस 26 नंबर का जो डॉक्यूमेंट है, the lordship has it, it is the final order in SCA 11184 of 2025. If the lordship opens these documents,
Yes.
this is a judgment for the final justice Moli Sheila, dated was 12/8/25. The lordship may note further that we are the petitioner. The petitioner is Gujarat State Financial Corporation, which is known as the Gujarat Government of Gujarat Undertaking, statutory body under the State Financial Corporation Act. But this is the petition we have filed. Can you see the order? Our learned advocate Mr. Soames for the petitioner, after arguing for some time, under the instruction of his client, he does not press the present writ petition with the liberty to file an appropriate application before the competent court for consolidation under three matters which have been mentioned. Regular civil suit number 65 of 21, special civil suit number 64 of 2019, and regular civil appeal number 166 of 2018 between the parties. Three judgments. This is categorically mentioned. Permission has sought for this granted. Lordship will note para 3.
Yes, yes.
It is open to file appropriate application seeking appropriate leave, and then the usual paragraphs
Very good.
that as and when.
Right.
Now, what has happened was this, that all these three purported matters arise out of the original loan transaction under which there was a secured asset with us, which we attempted to sell under section 29 of the State Financial Corporation Act. And this is an admitted position. Hereafter, after the public auction took place, one Messrs. Bias Associates, they were the highest bidder, and they were also were given the sale letter. There were some payments which were made. Subsequently, here is where the disputed portion arises. The corporation was given a letter notes by Bias Associates, where they requested that instead of us, kindly transfer this property in the name of Messrs. Ashwin Bayer, which is the opponent number 1 hearing, and Bias Associates is opponent number 2 here. But that is where thereafter the possession which was taken back, it was given back, possession was given to Ashwin Byers, and thereafter for a few years nothing happened. But by the time the payment was complete and the sale it was to be done, Bias Associates disputed that मैंने कभी मैंने वो change of name दिया, and there appears to be some internal dispute between them, which till date nobody has brought on record. Neither they have given us that what was their business understanding, why some payments were made by one party to another in the name of another, why was the request is now sought to be negated. But thereafter one suit was filed, intercept between them by Ashwin Nair against Bias, Singh and Associates. There they don't make us a part. Now that is not a suit for declaration, it is simply a suit for injunction. That lordships may have that it is a document number E1. Yeah, sorry. C1. Document number 10, copy of RCS 11 of 2002. In the list it is the serial number 10, and the name of the annexure is C1. Now, if your lordship sees the clause title, Ashwin Chingbai Shah, but he is the director, managing director of Ashwin Wire Products Limited.
Mhm.
That is the present opponent number 1. And a Prativadi, if your lordship sees Yad Singh and Rajput, then Sobat Singh Rajput and Rohit Yad Singh Rajput, Survey Pukta Umana Dando Vepar, they are the 3 defendants. So they don't join GSFC as a party.
Mhm.
The prayer, if your lordship sees at page 5 minutes of that is in Gujarati, but
मैंने कोई इशू नहीं
ये सर ये इंजंक्शन का ही प्रेयर है
मैंने कोई दिक्कत
कि
नहीं
जब तक आई विल जस्ट रीड मोर
बिल्कुल बिल्कुल
5A page number 5 at the bottom or lordship sees
અમવાદી ની સ્વતંત્રતા
હા એમાં લાસ્ટ લાઈન માં ગેરકાયદેસર અને કાયદા વિરુદ્ધ જઈને બળજબરી પૂર્વક કબજો લેવડાવે નહીં. Meaning thereby that without following due process of law, they should not interrupt with our possession. And possession was given by us to Ashwin Bayer, that is admitted fact. So they don't join us, they don't seek a declaratory relief. Now what happens is that this suit is decreed. And naturally, because they were put in possession and the possession was not disputed, either say if they have any issue on title, they have to file a declaratory suit and thereafter get the consequential reliefs. So it appears as if this suit was decreed in favor of opponent number 1. Thereafter, the opponent number 2 filed an appeal, and that appeal is not, if your lordship sees, the appeal number 166, which I have read. So this is the first round of litigation. Thereafter, the opponent number 2 files a suit, which at annexure B1. तो लिस्ट में वो डॉक्यूमेंट है 14.
याद सिंह द्वारा
Yes. Now this was a suit initially. Here all are parties.
Here all are parties.
Here all are parties. Now initially this suit was not for injunction, but thereafter an amendment application was moved. If your lordship sees the end of the page, English note, there is a order. But this is at D2, annexure D2. Annexure D2, document number 15, copy of modification application. But this is order 6-17. Kindly see, ये खत्म हो जाएगा फिर इंग्लिश में मतलब इसका ऑर्डर है. Order below exhibit 19 amendment application. Now what is the amendment? My lordship may just see. The amendment is that they have now sought specific performance from GSFC. Amended prayers are there, amended amendments are there. So therefore now this is a suit for specific performance filed by opponent number 2 hearing. Now this suit, unfortunately, he stayed because their application was made by the opponent number 1, who is one of the defendants, stating कि मेरा first suit जो है, therefore this suit cannot proceed. Now I would submit that section 10, and I will be showing the judgments. The section 10 is for if the second suit would operate as res judicata for the first suit, then and only then can it be stayed under section 10. But इसमें तो they are vastly different suits. One is for not taking possession illegally. Second is for specific performance after joining GSFC is a party with the main relief against GSFC. So whosoever succeeds, I will give them the property. Now this suit was applied under section 10 to be stayed, and it is stayed. Until that, I believe it is still stayed and nobody has taken steps.
Yes.
This is where we were. But thereafter, parties had gone to High Court one way or the other. There is a criminal complaint which was filed by Vice Singh against Ashwin Bhai. That complaint was initially, they were acquitted. Then in the appeal, it was set aside, order of acquittal was set aside. And that complaint is now revived. That complaint is still pending. So we said that till that this aspect of who is the actual person who is in default is settled, we will not enter into this AD. So they initially went to the High Court, and thereafter now they have filed a third suit
which is not the E1, is the annexure E1. Document number was 21.
Ashwin versus.
This is set offer number 2, Ashwin Soil Products Limited.
Yes.
Now kindly note, they only filed it against GSFs.
Yes.
This is a suit for specific performance. Now they have not joined the by-cement Rajput party. So for us, it is a difficult position because neither, supposing I ask a question to myself, supposing they fail in this suit, then what do I do? Today possession is with them. If they succeed and the other suit is kept pending, I can understand that claim is rejected for want of cause of action. Then there is no difficulty. Today that suit is simply stayed. Now, so what we did was pursuant to this suit, we filed an application under section 10. कि या तो दोनों सूट को स्टे करके तुम उधर सक्सीड कर दो अपील में और डिसाइड हो जाए कि कौन who is the person who is supposed to get the property. So one of them we will give the sale deed. So that section 10 was rejected and that is why we went to High Court. High Court said कि आप consolidation के लिए appropriate application करो, तो हमने किया. This is where we are, but this is the history of the matter. Now I would respectfully submit that the only way in this composite dispute can be resolved, because if you see the pleadings, but because the only thing which has to be seen is the pleadings in this suit, it is an admitted position that in all the suits, the base of the whole dispute is that who is the person who is the auction holder, that is in dispute. One party says I am, the other party says they are, and GSF is a neutral for this thing where we are in the middle of it all.
No.
Now, unless all these suits are consolidated, unless all these matters are consolidated, and there is a composite evidence which is laid by both the parties, that whether they can prove that their documents are right or whether the other party can prove that because they have not even till date made averments that what was their internal understanding. One says that I was supposed to take money from them, so I paid in their behalf. The other says that no, I have already given you money. You have forced my signature and gone ahead and told GSFC that you want to change. So the only way this whole issue can be settled, in my respectful submission, and that is what the High Court has also taken note of, that all the matters can be clubbed and kept together. I understand that one of them is the appeal, but the appeal also can be transferred. It is there. I will be showing judgments, and the section 24 itself says that appeal also can be transferred. Now, the only way is that the suits may proceed, both the suits may be kept together, and the composite issues may be framed, evidence may be laid compositely, and one final order court may say that the specific performance in the suit of one is to be allowed and the other will be rejected consequently, because the evidence will be evaluated together. And I will not then enter into the registered sale deed with that party. Of course, there is also some pending dues because कुछ payment बाकी रह गया था, उसका अभी interest के about 70 lakhs is to be claimed by me, which I have also mentioned. That would subject to that, the deal would be done. Therefore, this prayer. Now, curiously, opponent number 2 doesn't have a problem. कि हाँ आप consolidate कर. Opponent number 1 is having an objection, stating that no, my suit should proceed as it is. The other suit can be kept in, should be kept in abeyance, and the transfer or the consultation should not be allowed. That is fine, Lords, before your lordship. Otherwise, we could have jointly requested and kept it, and with the understanding that all the parties will cooperate for early disposal. Now, in my respectful submission, Lords, that the opponent number 1 has few grounds on which they are opposing. I have attempted to deal with all the grounds in my written arguments. But just 2-3 points I may point out, and there are some judgments which I have cited. I'll just quickly take your lordship to that aspect. May your lordship sees my written arguments for a moment, which I have filed today. Kindly go with me just to the provision of section 24 and 151, because the High Court has also observed 24 and 151, and this is a application under both. So page number 4 papers I have reproduced so that it is easy for the honorable court. Para 5, page 4. In the legal framework, but firstly, section 24, I may read what I have highlighted here. General power of transfer and withdrawal.
Yes.
On the application of any of the parties and after notice to the parties and after hearing such of them as desire to be heard, or of its own motion without such notice, the High Court or the District Court may at any stage. Now, what can be transferred? Transfer any suit, appeal, or other proceeding pending before it for trial or disposal to any court subordinate to it and competent to try and dispose the same. We withdraw any suit, appeal or other proceeding pending in any court subordinate to it, and then either try and dispose of it of same, or more subsequently it can give to any competent court. Therefore, in my respectful submission, but if let us say today your lordships are with me that all the three matters have to be kept together, then they have to be kept with a judge who can hear first the appeal as well. And then the appeal and the suits would proceed at the consolidated stage, and then evidence would be laid in the other two suits. And once the final order is there, the decree can take care of all the three put together and come to a composite decree. In my respectful submission was, I would humbly urge that this would be the best course of action given the broad checkered history. Otherwise, the litigation would continue to be proceed. If your lordships are not with me on the appeal, for the time being, I would submit that in any case, the appeal is, we are not the party to that appeal. And that appeal is only on the premise of injunction. Once the title take is decided, the possession will follow the title. The possession. So today, if it is decided that I have to enter into the sale deed with offer number 1, they are already in possession. I will enter into a title document with them, and that the appeal would therefore be rendered infructuous. If it is decided against them, then I would anyway have to take back the possession under 29 because they, assuming that they have exhausted their remedies, and then I would have to give it back to them, and therefore that appeal would be infructuous. So either which way, if your lordships are not with me as far as the appeal being consolidated together with the other matters are concerned, in any case, the second two suits have to be tried together because otherwise, it would lead to a multiplicity of proceedings. And if one suit, let us say, the section 10 application is ordered to be set aside and the suit proceeds, but there cannot be two specific performance suits against me from the same transaction. And if one court orders one, the other may order a conflicting order. The whole reason for 24 is this, to prevent this kind of scenario. And therefore, I would pray that both the suits will be consolidated and for a single court to be tried together. There are 2-3 points which I have raised, but the factual background on page 2 of my arguments I have given. Para number 3.
Yes.
But this is a admitted background that Vasani Wire Products was my loanee. I advertised for the property in Sandesh on 10/2/95 on the request of Bhai Singh and Associates. GSFC approved the change in the name, and that is how possession was handed over. This is the admitted facts. It is common to all the pleadings, and my learned friend would not dispute with me on the background of the matter. On the second page, I have given the history of the proceedings, which I have argued. Therefore, I may skip that. On the 4th page, I have given the provisions. 151, I would pray that it may be kept with the. And thereafter, the para 7, I have because they are saying that while the background is same, one is a concluded proceeding, one is a stayed proceeding, and mine is the only suit which is alive, and therefore it should proceed. In my respectful submission, that is more would create further complication. And because today that I can understand if the claim of suit number 2 was rejected. Today, it is always open for the plaintiff in that suit to challenge that section 10 application. And I will show from settled law that what is the scope and ambit of section 10, because I have to also answer to their point that the suit is stayed. Therefore, what the settled law on the subject is that when can the suit be stayed under section 10? Is very recent decisions of this Honorable High Court of Gujarat also there.
Till today, that has not been challenged.
Does not. But the point is, expressive words, the judgments would show that that stay cannot continue. Now, kindly appreciate words. For me, it doesn't make any difference. But for the if the dispute has to be settled properly, if this suit proceeds, let us see, and thereafter, after 1 or 2 months or 5 months or whatever, or even if this suit succeeds, it is not as if that suit is going to be disposed of by virtue of the final order in this suit. And that in the appeal also, because there is no prayer for the declaration, that court also can remand the matter, and none of us would be wiser after the years of litigation. Therefore, in my respectful submission, unless those two suits are at least consolidated, I can understand whether the steps are taken or not taken, it's a different issue. But unless the court is aware of the entire gamut of facts, because they are same, the documents and all which would be produced are same, the other this thing is same, history is same. So if second third suit is proceeding,
तो बोलो पुलिस वाले को, क्या प्रॉब्लम, क्या कुछ प्रॉब्लम है क्या हो गया? हाँ भी थोड़ी देर रुक जाओ, अभी साहब आया हुआ है, कोई घर से आया इनके पूछने में? उल्टी वगैरह तो नहीं आ रही? नहीं, वॉमिट वगैरह तो नहीं आ रही? बाहर चले जाओ ना, फिर इसको बाहर ले जाओ ना, आप इसका ध्यान तो रखो, वॉशरूम ले जाओ इसको, अभी ले आना थोड़ी देर में, आधे घंटा इसमें.
page 6C. I have answered this point, boss, and I will be taking a note. Page 6 at para 9. Answer to the stayed proceeding objection. Open number 1 contains that because special civil suit 64 stands stayed under section 10, this court cannot under 24 arrange any consolidation that touches the proceeding on the footing that it will override a mandatory stay. With regard to that, the stay order under 10 was founded on the existence of RCS 11 as a previously instituted suit, where the same matter in issue was directly and substantially involved between the same parties claiming under them. By now, RCS 11 has culminated in the decree, because if you lordship see the stay order is limited till the disposal of 11. Now 11 is already disposed of. To that itself, the order is not now over. But unfortunately, I am not appearing in those proceedings, and there is and thirdly, Gujarat High Court in Sangam Principles, which is the latest order of Minor Justice Padiwala, this issue is compositely covered, because there section 10 was applied for, section 10 was rejected, and the court then has gone on to examine in detail what is the scope of section 10, and come to the conclusion that when section 10 cannot be handled, when it can be stayed, and then if the consequential relief of not staying under section 10 is that both the suits will be tried together. So, plain reading of both the plaints, the fact that we are not a party to the earlier suit, and the fact that it is a suit for injunction, would ipso facto words, and in any case, the section 10 stay is limited till the disposal of RCS 11, and RCS 11 is now stayed. So court perhaps has not applied its mind as to what to do with that matter, or what to do with now that RCS 11 is disposed of. What has to be done with that second matter? So that issue is still germane, but today I have no other option but to and even on balance of convenience, because at the end of the day, I am the one party who is stuck both ways. My money is also stuck, and I cannot, even if let us say I am ordered to comply in one suit with the other suit pending, I will have to then either challenge that, or that proceedings will continue to go on. Because I am a government, I can understand if I am a private party, which government officer, I ask a question to myself, take this risk. because there is a criminal complaint pending, कल को उसमें हमारे सामने allegation होगा. We have no, मतलब say, stake in the matter in that sense. So that is why, we are approaching that if they can be all together, both of them can be set. So kindly see the judgments which show that
RCA का status क्या है?
RCA is pending, against,
For the judgment.
For the
And
judgment.
in the civil appeal, 166 is for the judge, cap for the judge.
final.
Final is
On which date? Yes, how much?
both the. अच्छा ना सध्या
Date પૂછે 10 સાલ વર્ષ નહીં, direct.
નહીં એ પણ પ્રેઝન્ટ જ છે આપણે કઈ
date
આર્ગ્યુમેન્ટ
પર?
કઈ ડેટે કરે 5
હાજી?
આપણે રિટર્ન આર્ગ્યુમેન્ટ છે ને બંનેમાં 166 માં
इसमें देखना अपने सॉफ्टवेयर में देख. 23
so other side advocate is also present here અરે ખાલી એટલું પૂછે છે 166 ઓર્ડર માટે છે ને આપણે બંનેની લેખિત દલીલો મૂકેલી છે હા તો વાંધો
oral
ઓરલ બાકી છે એવું કોઈ બંને રિટર્ન આર્ગ્યુમેન્ટ સબમિટ કરી દેશે બાઇન્ડર ઓર્ડર માટે મૂકી દે એમને ઓરલ
नहीं नहीं वो पता क्या है? वो पोक्सो कोर्ट है.
હા
तो उनके पास वही मैटर गए हैं जो फाइनल हियरिंग हो चुकी है. अदरवाइज तो दूसरे मैटर तो हम दे ही नहीं सकते हो. उनको वही मैटर दिए हैं जो जजमेंट मीनिंग देयर बाय जजमेंट. क्योंकि ये कोर्ट की रिक्वेस्ट पे ही गया था जो उनके पास मैटर पेंडिंग है कि उसमें हियरिंग कंक्लूड हो चुकी है इसीलिए उनको दी. नेक्स्ट रिपोर्ट को ठीक है जी. 23 है ना.
Because हम लोग तो उसमें पार्टी नहीं
आप पार्टी भी नहीं.
હજુ તો ખાલી આ એમ નહીં આપણે
બે કામ હોય સાહેબ એડમિનિસ્ટ્રેટિવ કામ એક હોય અને એક જજ સામેનું એલિગેશન્સ હોય તો ટ્રાન્સફર થાય આ સિવાય કોઈ ટ્રાન્સફર કરવાની જરૂર હોતી નથી અગર બધી પક્ષકારો હોય સાહેબ સેમ પક્ષકાર હોય સેમ રીત જેવું માંગ્યું હોય તો એ દાવા એક કોર્ટમાં ભેગા કરી હોય
इनका
એકોર્ડિંગ ટુ લો પ્રમાણે
इनका कहना है कि ये सैंडविच बन रहे हैं बीच में.
હા હવે 166
ये कहाँ जाएंगे?
આ સિવાય બીજું કોઈ અપીલ ક્યાં જ નહીં થાય
I am not multiplicity of proceedings.
એટલે બરોડામાં ફર્સ્ટ તરીકે ચાલે એ ટ્રાન્સફર કેવી રીતે કરી શકાય છે સાહેબ એની પણ દાદાઈ માગી છે તો આપને બતાવું સર
वडोदरा की कमाल.
એ નહીં
हिस्ट्री वो तो हिस्ट्री दी होगी ना.
એમ નહીં સર એ
ટ્રાન્સફર એટલે
સાહેબ સપોર્ટ કરે છે કે ઓપોઝ કરે છે એ ખબર નહીં પડતી હમણાં રિટર્ન
તમે જેમ નક્કી એ પ્રમાણે
ये तो record हिस्ट्री दी है ना.
હા
ये लास्ट
Yes, sir.
प्रेयर
હવે સાહેબ હું આપને કહું છું
प्रेयर तो लास्ट में 3 ही है ना.
હા
હા
હવે સાહેબ એમને હું આપને કહું મારું
ये आप आपके साथ हो गए ना.
नहीं मैं इनसे भी लड़ रहा हूँ
सेंसिबल
ये ही इज द एपेलेंट ऑफ द अपील आरसीए हाँ आरसीए 166 एपेलेंट है उनके
ओके.
आई एम द रिस्पोंडेंट
अच्छा अच्छा ओके.
ट्रायल मेरी फेवर में आया है
हाँ ठीक है.
मेरा तो सिर्फ 5 ही पॉइंट है
नहीं एक
हाँ इनको कंक्लूड कर देना फिर मेरे 5 ही
इसमें
point
आप अश्विन की तरफ से हो या उसकी तरफ से हो?
नहीं ये
बेहतर.
उन्होंने जवाब में समर्थन किया है.
अच्छा
अभी आर्ग्यूमेंट में
राइट सिंह
સમર્થન કિયા है ફક્ત ઓનલી પેરા 3 of the written statement
આપણે એટલે બધા ત્રણે મેટર ભેગી કરવાની છે.
ના તેને ભેગી કોઈ નથી બે જ મેટર ભેગી કરવાની લાગી છે
बेकअप इनकी प्रेयर भी
फॉर द 3
એમ નહીં
ठीक है आप तीनों मैं समझ.
हाँ
સ્પેશિયલ સિવિલ સૂટ છે ને 93/2010
हाँ हाँ.
એ પહેલા નડિયાદ કોર્ટમાં ચાલતું જ્યુરિડિક્શનના મુદ્દા ઉપર સાહેબ એ ખેડા કોર્ટમાં ટ્રાન્સફર થશે એનો નંબર પર છે 64/2019
ठीक है.
અને એક જે એનો જૂનો નંબર 96/2008 આ બંને કોર્ટોમાં જે મહેમદાસ કોર્ટમાં ચાલતો ચાલતા એમાંથી એક દાવો હતો ને તે ખેડા કોર્ટમાં એસટીમાં આવી ગયો અને એક મહેમદાસ કોર્ટનો એ બે દાવા મહેમદાસનો કોર્ટનો દાવો અને ખેડા કોર્ટનો દાવો એ બે એક જ કોર્ટમાં ટ્રાન્સફર કરવામાં આવે સાહેબ ખેડા કોર્ટમાં તો એનો વાંધો ના હોઈ શકે કારણ કે પાર્ટી એક જ છે તકરાર એક જ છે અને પુરાવો પડે પક્ષકારોને એક જ હશે.
To Kheda court, transfer to Kheda court.
ખેડા કોર્ટમાં ટ્રાન્સફર કરવો જોઈએ. પછી એમને અપીલ નંબર 166/2018 નું લખ્યું છે. હવે એની સાથે તો બીજી કોઈ અપીલ છે નહીં, એટલે તો થર્ડ અત્યારે હાલ જોઈન્ટ ડીજે સેકન્ડ જોઈન્ટ ડીજેમાં છે. એની ત્યારી 6 તારીખ છે.
ठीक है.
એની તારીખ ત્યારી છે. એટલે ફક્ત બે સાહેબ એમને કન્સલ્ટ આપે only the answer
नहीं ठीक है, बिल्कुल आपका
as per para 3 of the interpretation.
बिल्कुल ठीक. अब आपका सुनते हैं. एंड आपको सुनिए पहले इनको सुनिए.
However, second,
आपका तो आ ही गया वैसे लगभग.
judgment.
हो ही गया. तो जजमेंट दे देना वहाँ
This
पे.
called two
हाँ
things.
जी, हाँ जी, हाँ जी.
My main argument is on multiplicity of
हाँ ठीक है, राइट, बिल्कुल ठीक.
and conflicting decisions.
बिल्कुल ठीक.
So therefore, Manoj, because my learned friend is putting words in my mouth. My argument is on these two aspects, that there could be conflicting decisions in both the specific performance suits. In any case, there are multiplicity of proceedings, and therefore, that is my main ground. On the aspect of appeals, because the second judgment is there,
इसके ऊपर.
if you lordship want
Yeah,
to. I have give my the paragraphs at one. If lordship may I read those. So first judgment I will skip. It is on multiplicity. Para 3 I will like.
ठीक है, ठीक है.
But that
अपील वाले पे आ जाओ, मेन पे आ जाओ.
is. But in I'm the page number I have given at the top of the page 2, Manoj, I'm not sure. So,
पेज
1 second. 6 of the page 6 also. Of the combined.
सरजू देवी वाला जजमेंट.
Yes, Manoj.
हाईलाइट कर.
Yes, Arjun. Yes, sir.
ठीक है.
Yes. May I read first? Section 24 CPC is to the effect that High Court of its own motion without notice to the parties may at any stage transfer any appeal pending before trial or disposal any appeal to any court subordinate to it and competent to try and dispose of the same, or withdraw any suit appeal pending in any court subordinate to it to try and dispose of the same itself, or transfer the same for trial or disposal to any court subordinate to it and competent to try and dispose of the same. Since the UP Amending Act of so district judges are now competent to hear appeals at the instant one, and this court thought of transferring some of them to district judges concerned for disposal. But since the court's power to transfer them was a matter of controversy, this court took this step of issuing notices to the parties before passing orders of transfer. Except for the appellant in the instant case, all the parties are opposed to the transfer. So and so for the appellant in the instant case informed the court that he was instructed by his client to not oppose the transfer. We have the advantage of hearing the arguments of so and so in the instant case and so and so in the connected cases. The burden of the arguments advanced before us was that the so and so act has no retrospective effect, it does not govern the suits instituted before it came into the force. And in those suits, the parties acquired a right of appeal to the High Court from the second judge's decree, and that as a right has not been taken away by the so and so act, their appeals must be heard by this court and cannot be transferred to the district judges. Numerous authorities were cited in support of the view that a party to the suit acquires on the date of its institution a right of appeal in accordance with the law in force on that date. We were referred to so and so judgments that the proposition that a right to an appeal is a right acquired on the date of the institution of the suit is too well established to require citation of the authorities. Nobody disputes that in fact, despite of the UK Amending Act, the appeals were to be instituted in and to be disposed of by this court. If they are sent to the district judge is concerned, it is not on the ground that after the enforcement of the act, this court has lost jurisdiction to dispose of them, but by way of transfer by this court to the court of district judges under section 24 of the CPC. The right of a litigant to an appeal is always subject to the right of the High Court to transfer it under 24. The High Court has been given an overriding right to transfer a case to a competent court when it exercises this power, and there arises absolutely no question of any party's right being affected thereby. The power of transfer has been given in supersession of the party's right to have the case tried by a particular court. In other words, the right of the parties is subject to the High Court's power of transfer. When everywhere was High Court is equal to district court, because in our case it is same section. It cannot be disputed that though the parties have a right of action in the court exercising territorial jurisdiction over a particular area, the High Court can transfer the case to another court, though it does not possess the territorial jurisdiction of the area. If the district judges are competent to dispose of these appeals, this court has the power under 24 to transfer them to them, regardless of the question of the right of parties to have them disposed of by this court. The question, therefore, that should arise is whether the district judges are competent to dispose them of or not. Since the right vested in this court to transfer the appeals is in supersession of the right of the parties to have the appeals disposed of by this court, it follows that the question of competency of the district judges is to be determined without any regard to the right of the parties. The competency is to be seen not with the reference to a particular jurisdictional facts involved in the appeals, but generally with the reference to their nature. It may be that these appeals are within the jurisdiction of this court, but if in their general nature they are also within the jurisdiction of district judges, they must be held to be competent to dispose them of after the enforcement of the act. Appeals of this nature are within the jurisdiction of the district judges. They have been given the jurisdiction to dispose of them, and that is how the transfer took place. So here, perhaps, in my submission, there is a slight transposition. The appeal, the suits perhaps will have to go to a court of a higher jurisdiction if they have to be clubbed together. But in my puts a question that is not barred under the section 24. And in any case, note, sir, the parties, there is no right of the parties which is being infringed for them to actually oppose it. If they really want the evaluation of the inter se rights, this would perhaps in my respectful submission be the best course of it. That is why I want my first prayer is to have all the three put in the same court. And therefore, the alternate prayer which my learned friend now is. But thirdly, note, sir, the third judgment is also on conflicting decisions and pleadings that I will not speak. Judgment 4 is on one of the wide power and lack of restriction, because there is no restriction which is put in 24. In my respectful submission, it cannot be said that appeal cannot be kept with the suit. There is no such restriction. In fact, it is very wide. It says suits, appeals, or any other proceedings, and the words used are at any stage, meaning thereby that if some suit is already therefore in my submission. Judgment 5 is on consolidation, because mere transfer will not, it has to be heard together. Evidence would have to be laid together. Issues would have to be framed accordingly, and that is why the judgment. The paragraphs I have given. If you also want me to mark the paragraphs. First judgment, para 3. I have actually this first judgment, para 3. Second judgment, para 2 to 10. Third judgment, para 7 towards para 10. Fourth judgment, Kerala, para 4 to 6. Fifth judgment is towards head note and paragraph 11 to 14. That is on consultation. Sixth judgment towards para 19 onwards. But this is that section 10 where will be judgment. This is on section 10 because I will have to answer that point. Now may I take a lordship notes to para 19 of that judgment, starting on page 40. Having heard the learned counsel appealing to the parties and having gone through the materials on record, the only question that calls for our consideration is whether the court below committed any error in passing the improved order. Section 10 of the Civil Procedure Code reads thus: no court shall proceed with the trial of. Yes, that I may speak that. Para 21. The aforesaid section provides that where a suit is instituted in a court, such court shall not proceed with the trial of the suit if the questions in controversy in the suit are also directly and substantially an issue in the previously instituted suit between the same parties. Here neither is the issue same nor are the parties same. That is one aspect. Further, I will read page 45. Further, it is provided that previously instituted suit must be pending in the same court in which the subsequent suit is brought, or in a court having jurisdiction to grant the relief claimed in the subsequent suit. The object of this section is to prevent the courts of concurrent jurisdiction from simultaneously trying two parallel suits relating to the same questions in dispute. This section does not contain any reference either to the subject matter or to the cause of action. And this is most important. The test for applicability of this section is whether on the final decision being reached in the previous suit, such a decision would operate as a res judicata in the subsequent suit. Here was there, this would settle the issue. Because first suit, even if they are granted injunction, in the second suit is for specific performance against us. There is no injunction in the first suit against us, which is sought. So if the second suit proceeds, if the suit is decreed, it would not operate as a res judicata. The previous suit would not operate as a res judicata, and I will enter into a sale deed with them. Right now, I am assuming the third suit has not come out. Therefore, was in respect to submission, this is a fallacy. Now, in these kind of facts, what the High Court has said is that the consolidation is the only remedy. Para 31 minutes. Is on page 45. Because this was the alternate way, then Mr. Shah submitted both the suits can be ordered to be tried together. In other words, according to Mr. Shah, the two suits can be ordered to be consolidated, or both the suits may be ordered to be tried by one particular court, by court one after another. Then the whole discussion of that takes place, and kindly see parameters 40. It is not in dispute that the causes of action in the two suits are altogether distinct and different. Although the agreement of sale in both the suits is common, yet that by itself is not sufficient to invoke section 10 of the CPC. As held by the Supreme Court in the case of Aspijal Supra, the entire subject matter of the two suits must be the same. Section 10 CPC will not apply where few of the matters in issue are common, and will apply only when the entire subject matter in the controversy is said. In other words, the matter in issue is not equivalent to any of the questions in issue. The Supreme Court in so and so has laid much emphasis, and thereafter on the discussion, finally, para 50. Para 50 notes. We, however, in the wake of the aforesaid discussion, would like to pass an order for consolidation of the two suits. We take notice of the fact that the subsequent suit, that is the commercial suit so and so, is pending as on date of the principal senior civil judge, whereas the regular civil suit instituted in the first point of time is pending in the other court. We order the transfer of the RCS from the court of so and so to so and so, in which the commercial suit is pending. So lower wale se higher wale mein dal diya. And the court may frame consolidated issues if required, taking into consideration the pleadings in both the cases, and thereafter have a consolidated trial. This was the way out which was called out. In this case also we would probably play the very same.
Right.
Please, the last segment is also on that point, and last segment is also on 151. That this is a unique case, loss. That it requires a certain creativity on the part of the honorable court to see that the issue is settled once for all, and therefore 151 is also I'm declared.
So the prayer is on the para number 22.
Number 22.
22 of the main petition. Your Honor may be pleased to issue direction to consolidate the trial as well. Hearing of the following three civil cases appeal. The first is regular civil appeal number 166, which is pending before the second district judge court, which is against the order dated 22/12/2017 in regular civil suit number 11 of 2002. Second is special civil suit number 64 of 2019, which is pending before the civil judge Kheda. And the third is regular civil suit number 65 of 2021, pending before the London civil judge Memdawar. Now, I have only 5 points to argue. I'm not going to into merit of all the cases or something. First, the defect of the application. The regular civil suit 11/2002 is concluded proceeding. It was finally decided on 2017 by the competent court in favor of the opponent number 1. The power under section 24 CPC can only be exercised with the respect of the pending proceeding. A suit that has already been decided is no longer the pending and cannot be considered with the proceeding. Any attempt to include such decided suit would be indirectly reopen the issue. Already trial has been concluded, the issue has been framed, the court has already decided the merits. Now, if the appeal is concluded trial with the lower court, so what is harm to me? So indirectly reopen the issues already adjudicated and would violate the doctrine of the res judicata under section 11 of the CPC. That is my first submission. Second submission is section 10. 64/2009 presently stayed under section 10 of the CPC, dated 8/2016. No appeal has been filed. 8 August 2016. 8/8/2016. Mandatory statutory stay and the discretionary power under section 24 CPC cannot be used to override such a statutory mandate. Therefore, the proceeding which is legally stayed cannot be consolidated with the proceeding which are active proceeding. What their purpose is to file this application? Any direction, common evidence, joint hearing, or consolidation, adjudication would effectively permit and progress to states. What cannot be done directly under the law cannot be achieved indirectly through the section 24 of the CPC or section 151 of the CPC. 151 is a two inherent power which can be exercised only on the two cases: if abuse of court process of law or end of justice. Both are missing here. They just what the purpose is. 2016 में सर उन्होंने एक स्टे ऑर्डर हो गया, उनके ऊपर अपील नहीं की, अब उसको स्टे हटाने के लिए सेक्शन 24 का यूज कर रहे हैं. क्यों? अगर ये कॉन्सोलिडेट होगा तो वो स्टे अपने आप हो जाएगा. क्यों? क्योंकि कॉन्सोलिडेट होगा, इश्यू सेम फ्रेम होंगे, कॉन्सोलिडेट ट्रायल होगा, तो वो ट्रायल रन हो जाएगा. उसके ऊपर उन्होंने कोई अपील नहीं किया, उनको ये ऑर्डर उन्होंने एडमिट कर लिया हुआ है. तो वो लोग इनडायरेक्टली सेक्शन 10 का जो स्टे है उसको उठाने के लिए सेक्शन 24 का यूज कर रहे हैं. टोटली अब्यूज ऑफ कोर्ट प्रोसेस है इनके हिसाब से. हमारे हिसाब से कि ये जो 24 की एप्लीकेशन है वो अब्यूज ऑफ कोर्ट प्रोसेस है. थर्ड, the parties are not same. It is admitted fact, sir. The first suit, which is completely trial has been adjudicated in 2017. GSFC, the present applicant, is not party to the proceeding. So my 5-point argument is that the suit decided cannot be consolidated. Second, that the stayed proceeding cannot be clubbed with the active proceeding. Third, that an appeal cannot be merged with the pending suit. And fourth, the parties of and the cause of action and the reliefs both are different in the every suit, so cannot be clubbed and combined trial cannot be concluded. So my humble submission is this application should be rejected with the heavy cost. Obliged, sir.
Just one point in rejoinder on the aspect of stay. The document of stay is at annexure 80 in my list. Because my learned friend keeps saying what that stays. Annexure 18, D5, not sheet for this open letter. Lordship says, chopal lagat hukam. But kindly see that hukam 2 pages after, page 5. Hukam. Lordship को mark is. આ કામે પ્રતિવાદીની 17/8/55 ની અરજી મંજૂર કરવામાં આવે છે. સેકન્ડ પેરેગ્રાફ. હાલના દાવાનો ટ્રાયલ મહેમદાવાદ ખાતે પેન્ડિંગ રેગ્યુલર દિવાની મુકદમા નંબર 11/2002 ના દાવાનો નિર્ણય થાય નહીં ત્યાં સુધી સીપીસી કલમ મુજબ સ્ટે કરવામાં. હવે એ દાવો તો પતી ગયો, તમે એક્સટેન્ડ કરવાની અરજી કરી હોય તો બતાવો.
હું એપેલેન્ટ નથી ભાઈ.
No, no.
હું એપેલેન્ટ નથી.
This stay has expired in the subsequent suit. Have you applied for its extension?
અરે હું એપેલેન્ટ નથી ભાઈ.
Therefore, there is no stay. This stay was only till the disposal. Now the court has to apply its mind whether it is to be was continued or not. Either the suit has to proceed or it has to be rejected. Now this stay is conditional and the condition is over. Therefore, these are all technical things. What the unfortunately was it is in everybody's interest. Please, Madam Others.
મારા મિત્રની એપ્લિકેશન છે ભાઈ, એમાં પહેલા બાબત ક્લિયરમાં ફર્સ્ટ પેરેગ્રાફમાં રેગ્યુલર સિવિલ અપીલ નંબર 167/2018 standing before the London District Court, Nadiad, against order parties, Park Agents, because the leadership number 3/2002. As Mehmdawad. This was now discussed in appeal taking so Sasha Beja. Rather than the film matter inside. We giving according to Roma, no, the party challenge. Where telegraph any other second point. Patients in September concert major of the banking before London. Principal senior speaker at Kheda at Nadiad. At Kheda. If patients who concert major rules, energy pop starts. And the regular swing should come to concert major exist. They say principal switcher Nadiad in the chapter. એટલે આ મહેમદાદ બિલવાનો જે દાવો છે સાહેબ એ સ્પેશિયલ નંબર 64/2019 સાથે ભેગો કરી શકાય. કારણ કે રેગ્યુલર કોર્ટ રેગ્યુલર સ્પેશિયલ એસટી કોર્ટ નથી. મહેમદાદનો તો ટ્રાન્સફર નહીં કરવો પડે સાહેબ. મહેમદાદનો દાવો એ દાવા ભેગા છે તો પાર્ટી એક જ છે, પत्राઓ એક છે બીજા એના શાળાઓ કંઈ ડોક્યુમેન્ટ પણ એક છે. આ દાવો જે છે મહેમદાદ છે એ સાહેબ મદ્રાસ કોર્ટની અંદર ટ્રાન્સફર કરવામાં આવતું નથી.
Obliged.
It's a payment, single purpose. Okay, sir, I'm for the insurance company. एक एप्लीकेशन दिया है टू व्हीलर के ड्राइवर डिजीज तो उसको पार्टी बनाने के लिए एप्लीकेशन की प्रोसेस पास करो उसकी जो नेग्लिजेंसी है लगेगी यू कैन नॉट मीट बस ठीक है बच्चों जो पास कर लो बस कुछ थैंक यू guys कितने कितना दे एमएससी की फाइल करने हाँ
क्या नाम है तुम्हारा? छोड़ दिया ड्यूटी, एडमिट कर, बॉन्ड दे देना, 10,000 का बॉन्ड। जी सर, 10,000, 10,000 का बॉन्ड, बेल बॉन्ड। अभी प्रोसेस थोड़ा कंप्लीट